Below the reply to the questions would be found where Rabindranath Bhattacharya says no aptitude test, Rafi Kalam says test taken, Prabhat Roy says no test, Ratan Bala says taken, Arun Kanti Niyogi says not taken. Well, some say taken, some say not taken. I place that everything was on record that aptitude test was taken at the appropriate time. But this is what has transpired, Millard, from the examination by the judge. Then after the table, kindly look into this sentence. No questions were asked by the appearing parties to the above interviewers. Matter ends over there.
Because
Parties-
the answer was partly in their favor. Because some said no aptitude test.
Maybe or may not be. But what is the legal position your lordship would kindly consider?
Okay.
The evidence recorded are kept on record. It is to be noted that there was no formal engagement letters for acting as interviewer. All of the interviewers were called over phone to take interview. There was no guideline for awarding marks for aptitude test, where the learned judge forgets the rules. A large number of interviewers were not intimated by the board that there is one aptitude test, a different test altogether also beside interview. One interviewer so-and-so said that he took aptitude test, but when asked what was an aptitude test, his reply was aptitude test means confidence and body language of a candidate. Therefore, 36,000 appointments should go. Then please take me to the next one, which is 5th of April 2023 at page 436, where the interviewers over. Now kindly take Willard, 5th of April.
Yes.
I direct the superintendent of the Presidency Correctional Home to produce Mr. So-and-so physically before this court. The superintendent is directed to make arrangement for necessary police force, etc. One of the parties had Millard prayed that this gentleman should be brought before the court.
Yes.
So this was adjourned till 3 p.m. Now kindly take Millard at 4:20 on the same day, Millard, this order was recorded. This is at page 437.
No. Yes, page 437.
Millard, 5th of April 2020.
Have you been interrupted by anybody?
Mr. Bhattacharya is sleeping. And I and Mr. Shanal could not find any reason.
You should interrogate him.
Yes. Why should he be drowsy?
Yes, 437.
Well, the second paragraph, my lord. The hearing is not complete. Respondent board will make its submission in respect of the argument made today by the petitioners. Thereafter, the petitioners will be given opportunity to reply to the submissions to be made by the board. Pursuant to my direction, so-and-so was produced before this court by the so-and-so. Some relevant questions were put to him which were required to be known by this court.
Yes.
Some relevant questions were put to him which were required to be known by this court for full and complete adjudication of the matter. Mr. Bhattacharya has replied to that questions which are recorded as below. I am asking some questions to the erstwhile president of the West Bengal Board of so-and-so, exercising my powers under section 165. Mr. Bhattacharya, any selection committee was constituted for the 2016 recruitment process? Yes. The selection committee was constituted by the board. Who published the result and who prepared the result of 2016 recruitment process? The deponent first said that he does not understand the question. Then he said that it is compartmentalized and made some statements as to the compartmentalization. Whether any other outside agency was engaged to prepare the result of 2016 recruitment process, the board has acted in accordance with rule so and so of the recruitment rules. The question is, was any specialized agency engaged? Yes. What was the name of the agency? I have to go through the records. I cannot remember. Have you ever heard the name of P. Basu Ray and Company?
Yes.
Your lordship will not find this name in any pleading.
Yes.
Your lordships would not find this name in any pleading. I won't say anything more. Mr. Tiwari is here, Lord, he'll contradict me.
Yes.
Answer is maybe, I'm not sure. I have to go through the records. Did you know whether any aptitude tests for the candidates were taken? Yes, of course. Aptitude test was taken. There is no report during my tenure as the president of the board that aptitude test was not taken. Are you sure that the reservation norms were followed in 2016 recruitment process? Another additional factor comes. Reservation. Reservation policy was, as was incorporated in the rule itself, was followed. There was no allegation or information during my tenure that reservation policy was not followed. Mr. Bhattacharya, is there anything against you personally in respect of the matters pending before this court against the board, which are now in the hands of CBI or ED? No personal allegations till date has been made against me. The witness volunteers, without any pretext or context, the Honorable Court has asked me some question and I have given answers to that to the best of my knowledge. Mr. Bhattacharya was handed over to the correction law, etc. Fix on so and so.
Yes.
Order data one. Bhattacharya এমন কিছু নেই। Well, on 12th, my lord, we pray for directions for filing affidavit.
Yes.
Then 19th of April also, my lord, affidavits. Then, my lord, the hearing starts. Hearing concluded. Now, my lord, take the judgment.
12th of April 23.
12th of May 23.
12, page 442.
Well, it's no. I'm sorry, my lord. Yes, but I have it, my lord, at 611. Your lordship may look from that page also.
611.
Yes,
তাও
it would be made in the other volume.
যদি সেভাবে যাও। But what is this page 438 or
Well, it's the same judgment. Judgment under the appeal. 12th of May 2023. It's at two places where I have read it here from page 611. Yeah.
এটা হচ্ছে এর নয়,
No, ওগুলো আমার।
April 20.
12th April.
No, final order is 12th of
May.
Yes.
Now, well, this is the final judgment which is under appeal.
Yes.
This writ application has been filed by 140 petitioners who were qualified in TET 2014 and participated in the 2016 recruitment process but did not get appointment. The recruitment process was held by the West Bengal Board of Primary Education, which was to be held in accordance with the recruitment rules, which came into effect. Rule 6.3 of the rules in Rule 6, Sub-Rule 3 of the said rules, the following provision has been made. In the matter of appointment, priority shall be given to those eligible candidates who possess the minimum qualification as specified by the National Council of Teachers Education and MHRD, and thereafter the eligible candidates with the relaxed qualification specified by MHRD may be considered, and if candidates with relaxed qualifications are considered as teachers, such teachers under the relaxed qualification norms shall be appointed with an undertaking to acquire the minimum qualification specified in the NCTE within a period of 2 years from the date of appointment. Under the said rule, Sub-Rule 3, 8 notes are there which would be taken into consideration if required. When the petitioners filed the petition, they wanted the authorities to file a report disclosing name, numbers, rank, category, etc. of the non-trained candidates who have been recruited by the board from 2014, including the date of recruitment, and to treat the petitioners equally with the non-trained candidates, etc. During the course of hearing, the petitioners disclosed various particulars collected from the publication made by the board in its website, showing that there were serious illegalities in preparation of the panel of 2016 recruitment process when viewed in respect of untrained candidates at the time of recruitment, and while disclosing such particulars, they made it clear that all their allegations of illegalities in recruitment were in respect of untrained candidates at the time of recruitment who were given appointment against 2016 recruitment process. And at the same time, it was made clear that they do not have any grievance with respect to the trained candidates who were trained at the time of recruitment and were given appointment in the 2016 recruitment process. Therefore, the candidates who were trained at the time of recruitment are outside the scope of this matter. The petitioner prayed for filing supplementary affidavit, which was granted, and from the supplementary affidavit to the writ application, it became evident that all the petitioners had qualified TET 14 and participated in the 2016 recruitment process, and they were called for interview, but they did not get the job. Millard, the aptitude test calling, Millard, which was recorded in the first order, is missing. Now, the Honorable Judge records that only interview. This court directed. Now, Millard, the court is, Millard, inviting or calling for evidences. This court directed the board to file one report as to the petitioner's breakup of the total score sheet of 2014, TET 2014, along with the breakup score of the last empanel candidate in their respective medium category and district who participated in the recruitment process of 2016. From the breakup, the petitioners found that the alleged that the particulars given therein are absolutely false, as because the lowest number of empanel candidates was shown in the report as 14.191, whereas throughout West Bengal, 824 candidates who scored below 13 were appointed, and the petitioners prepared a tabular sheet to that effect and enclosed it as Annexure B to their exception to the report filed by the board dated 11/1/23. Such exception was filed in the form of an affidavit affirmed on 24th January 23. It was also stated in the exception that list of the last impanel candidate of different categories, namely General SC, ST, OBC A, OBC B, was not given. I have found that there was no reply of the board in respect of the allegations as aforesaid in the affidavit in opposition filed dealing all the pleadings of the petitioners. From the pleadings of the petitioners, it is found that they wanted the marks of the last impanel candidate of different categories like SC, ST, OBC, etc., but no such particular were supplied and produced by the board despite direction given by this court. In the affidavit in opposition of the board maintained silence in this regard. This is nothing but suppression of facts from the petitioners as well as from the court. In respect of holding of aptitude tests, the chairman of the board in his report said that the aptitude tests were taken, but from the evidence adduced by the interviewers and the candidate, it has been proved before this court that no aptitude test was taken. We are pausing here for a moment, Pilot. All relevant records were before this court, which is part of the paper book, to show that in every district, Willard, aptitude test was taken. But with respect, the Honorable Judge do not refer to any of them. The Honorable Judge confines this adjudication to whatever was elicited under Section 165. Pleadings and evidence on record, Millard, in my very respectful submission, has been ignored. In this regard, The order passed by this court in this matter on 6/2/2023, not challenged till now, is required to be quoted. My lord, that order is quoted, where I placed that order, my lord, with the,
No, Mr. Dotto, where they called for the aptitude test.
yes, yes. We have all records annexed. I'll not go elsewhere.
So
This paper book
what-
itself.
The evidence which was extracted as you were submitting, that is relating to the issue whether aptitude test was held or not.
The issue which the honorable judge considers at the time of final adjudication is only
Aptitude
confined
test was-
to whether or not aptitude test was taken.
Yes,
Although, my lord, no pleading was there. That's why, my lord, I have taken your lordship through the writ petition. Then, my lord, if your lordships may kindly skip over the table
Excellency.
at page 617, after the table, no question was asked by the appealing parties to the above interviews. The evidence kept on record. It is to be remembered. This is the quotation of that order. I skip over those. Now, please take paragraph 10. Then page 618, para 10. Therefore, the marks given to the candidates against aptitude test is wholly illegal and false exercise to hoodwink all concerned, including the court. Paragraph 10.
Yes,
But so long, my lord, the finding was that no aptitude test was taken. The interviewers have made contradictory statements in course of their deposition. Now, kindly see paragraph 10. Therefore, the marks given to the candidates against aptitude test is wholly illegal.
maybe the judge thought that the aptitude test which had been held is not in terms and in consonance with the
Well,
rules.
let us simulate whether that has been held or not.
This issue as whether aptitude held or not, this I think will go because subject to what you say. Because maybe Lordship was proceeding on the basis that test which was held was a sham test.
Right.
That is, I think, the
Yeah.
ultimate
There cannot be two
two versions.
versions. Either the aptitude test was taken. If taken, it is faulty or correct.
Hmm.
That can be one situation. The other situation was no aptitude test taken.
I think
So long, my lord, we had a understanding from the judgment that
there was no
no
aptitude.
aptitude test.
Hmm.
Therefore, the marks given to the candidates against the aptitude test is wholly illegal and false exercise to hoodwink all concerned, including the court. The board has not given any reply in respect of awarding 9.5 out of 10 marks to a large number of candidates, which is absurd and an impossibility, especially to those whose academic score and TET score were very low. The table given below substantiate the allegation apart from 121 pages booklet, spiral binding, which is on record. The spiral binding, cannot be a pleading or an evidence.
So who made the spiral binding?
The petitioners, writ petition.
Record with us.
Yes, that we have put in the paper book. It's in the paper book.
Yes.
In support of their allegations as to corruption in awarding marks in the interview, the petitioners have filed a booklet of 121 pages on the basis of which it has been alleged that the candidate whose marks were very poor in secondary, in higher secondary and in TET has been given 9.5 out and 10 marks, that is full marks out of full marks 10, that is the perfect 10 in the interview and aptitude test. No aptitude test was taken at all. And the allegation that there was no aptitude test which has been proved before me. Who has proved this? The proof has to be preceded by an allegation, an assertion, a pleading.
Yes.
But how it has been proved, I'll come to that later on. But Millard, before coming to the conclusion that it has been proved,
Yes.
one must come up with an allegation. Proved before me from evidences of the candidates and from the interviewers which are kept on record. Here, to elicit the truth, I had to exercise my power under section 165. For example, some particulars have been given in the said 121 pages booklet, which has been prepared from the particulars published in the web portal of the board. By the board, some candidates' marks were reproduced herein below, which shows that the marks awarded to such candidates whose results are very poor in secondary and in higher secondary examination and also in TET are wholly absurd. Assessment in interview, and unless some extraneous factors, which includes corruption, as has been alleged by the petitioners and now has come to light from the investigation by CBI and ED, such absurd marking could not have been made by the interview boards in different districts. While looking into the following particulars, it has been noted by me that in the academic assessment and TET, 1. The maximum marks that could be given against secondary examination score of a candidate was 5. The maximum marks that could be given to a candidate against high secondary examination score of a candidate was 10. The maximum marks that could be given to a candidate against TET was 5. Therefore, the maximum marks that a candidate can get against the above three heads is 5 plus 10 plus 5 is equal to 20. Now I give example of a candidate before giving a table prepared from the document or record, that is the 121 page booklet. This candidate has got 2.866 in TET out of 5, 1.462 in secondary out of 5, and 3.050 in high secondary out of 10, totaling to 7.378. But was awarded 9.5 marks in interview and aptitude test. Aptitude test was not taken out of 10, whose total score came to 16 point so and so, and thus he became eligible for appointment as a primary school teacher. Huge number of such absurd awarding of marks has come to light through the said booklet prepared from the particulars published by the board. Miller examples given. For example, Putul Bormon Singho, total marks in the academic qualification is 7 point something, and the interview marks is 5.0. Similarly, Monimala, etc., etc. This the Honorable Judge records. Then kindly, after the table, para 15. The board has not given any reply in respect of the allegations of the petitioners in the pleadings as to non-empanelment of the reserved category in the panel for general category candidates of those reserved categories who got better marks than the general category candidates in the open competition. Thus, the board has violated the law declared by the Supreme Court and has committed extreme illegality. Though the relevant Rule 7 of the recruitment rules of 2016 mandates constitution of the selection committee, no selection committee was constituted for the purpose of selection of eligible candidates and preparation of panel of such candidates for appointment of teachers. It was done by one outside agency, a third party, which was not at all a part of the board, and this third party was named as confidential section of the board. This is clear violation of the recruitment rules. The board has maintained complete silence. From the gross illegality in the selection procedure in recruitment exercise of 2016 conducted by the board, it is clear that the board and its officials, including the former president who is now in custody so and so, conducted the whole affair like affair of a local club, and now it is gradually coming to light by investigation of Enforcement Directorate that jobs of primary school teachers were actually sold to some candidates who made money to who had the money to purchase the employment. A corruption of this magnitude was never known in the state of West Bengal. A former education minister, the former president of the board, and a number of middlemen through whom the jobs were sold like a commodity are now behind the bars, and the CBI ED investigation is being continued now in full swing. With respect, Miller, paragraph 17 has got nothing to do with the merits of the matter.
It's a scam, Mr. Dotto.
That scam, what they say, scam, please see whether at all there was anything in the petition.
No, right. You have
Yes,
told us
yes.
that there was
Nothing
no
was there.
pleading.
Miller, simply Miller using this catch expression, scam, corruption, scam, corruption, doesn't mean that a case is proved. A case has to be proved even if it is scam.
So there will be no perception of the judge.
Milord, in that case, Milord, the judge should first release the matter.
First,
Release the matter with
the
respect.
perception in the sense from the record.
Milord, no, no,
his
these
own
are not on
perception.
record. Milord, these are the personal views of the judge. But how could the honorable court get the name of that third agency?
If it is ultimately shown by them that their system,
Whether it is shown by them, right?
these are all factors inextricably bound. You cannot segregate without.
No, no, these were not placed before the court. I'll come to all the pleadings one by one. It has to be there in the pleadings.
The pleadings you have shown. Pleadings you have
Nothing is in the pleading. I'll come to the other pleadings. I've just taken your lordship through the writ petition. Other things where and the sequence of pleading is also very important. When did the court invite which pleading? That is also very important. Where I have a short list of dates for that also.
So that we will hear. We are
Yes.
just interacting with you.
Right.
We
Definitely.
are asking you
Yes,
that
yes.
when there is such a heart-throbbing issue of scam, which you say that it has to be different definitions can be given. But it is a fact that there had been a scam in respect of several education.
But that will not, Milord, vitiate the other selection process. Milord, one selection process said to be bad doesn't mean, Milord, the
Can be argued against you that in order to divert from that issue, you are taking up the very basics as to whether there were any pleadings. Maybe this may be an argument on their side.
yes, yes,
also.
definitely. Yes, yes.
That.
But I will deal with those also.
Yes, yes, yes.
But
Yes.
otherwise, Milord, the whole Milord, the writ jurisprudence, Milord, has to be rewritten.
Yes.
Where your lordships have in a number of judgments held that whatever is there in the pleading as well as in the evidence, the court will only look into that.
Seven except in extraordinary cases.
Yes. That extraordinary case has to be made out by the parties, not by the court. Court is not going to make out a case for one of the parties.
Yes. Yes, page.
Yes, ma'am. But I was placing paragraph 17.
Yes, 17. You have finished 17.
Yes. Now kindly take paragraph 18.
Yes.
Now kindly see but how we are being dealt.
16 17 শুরু করুন।
Acha, 17 where I have not started. From the gross illegality in the selection procedure in the recruitment exercise of 2016 conducted by the board, it is clear that the board and its official so and so naita পড়া হয়ে গেছে. Now please take paragraph 18. This is very important for me. Kindly see not how my arguments are being dealt with. It is a matter to be noted that the board in its affidavit in opposition while dealing with the pleadings of the petitioners, instead of addressing the allegation of corruption and illegalities in the recruitment process, raised some niceties of law and some principles of law, but however nice or however laudable, those principles may be, this court as a court of justice will fail to deliver justice, knowing fully well that sense of justice is much above the sense of law. If the writ application is thrown out on such niceties of law, as this will mean that in the name of preserving the law, the corruption would be protected, with which a constitutional court can never do, keeping in mind the soul of our constitution and the constitutional conscience. I say that in this recruitment scam, stinking rats are being smelled. So whatever rubbish I have said, that has to be dealt with by the court. Kindly see the next sentence. Even more alarming, the board placed some judgment before me in support of the niceties of the legal principles, which I do not find have any applicability in the face of the magnitude of the stinking corruption in the recruitment exercise of 2016 conducted by the board. These judgments are not required to be mentioned at all. Well, this is how, Milord, the advocate is being dealt. Say that these judgments are not applicable because of so and so reason.
At all in the facts of this.
No, he has not. I have referred to at least 20 judgments, not even recorded. That is why, Milord, with respect, Milord, the Honorable Court, Milord, bypasses the application of the principles by saying that these are niceties of law. As if, Milord, in writ court, niceties of law is not to be argued. It is a Bhakcha's court. Kindly see. Now, kindly see the expressions thereafter. Those judgments are not required to be mentioned at all in the factual situation of the case, as those are the bright stars of the space, much, much above the ground realities, in which the unemployed youths live with tears in their eyes, because this recruitment scam is a crime against the society and also a fraud